Hello, this is Daniele Idini for Cassandra Voices.
Over the past few years, it has become widely accepted that in Ireland, providing adequate protections for whistleblowing and whistleblowers is a lot more difficult in practice than in theory. In many fields, extreme life consequences for a brave decision to go public with revelations of wrongdoing have been apparent. The protections currently in place do not shield individuals from the repercussions of one's personal and family life or career in full. We are talking about losing one's job, harassment, unwanted public exposure, grave false allegation, framing, protracted legal challenges, financial difficulties, and so on. All too often, such individuals are dismissed as rats. There follows death threats and the potential for imprisonment. At any level, such a decision is a life-changing event. In many cases, it's traumatic. There are many examples to be made, as back in 2017, banking whistleblower Jonathan Sugarman testified to the Oireachtas that official Ireland has absolutely and completely destroyed the lives of every single whistleblower who has come forward from whatever walk of life they've come. We asked the question in Cassandra Voices, does Ireland still have a problem with whistleblowing? Even now, in 2021, after much debate and revelation, and with the Irish whistleblowing legislation being under process of amendment to be in compliance with EU law, it is alleged that the culture of exercising whistleblowers persists in the civil service, in the Garda, as well as financial and other corporate institutions. Has Ireland got any better for whistleblowing after years of revelations, media coverage and resignations? Or things pretty much as they always were, if not worse? I posed this question to human rights barrister David Langwallner, who was asked by Sinn Féin to help in draft a private member's bill which they proposed to introduce to the Dáil by July the 31st, 2021. David, can I ask you what's happening these days in regards to whistleblowing in Ireland?
What happened was, and I've got to be a bit circumspect about this, I was approached by a former client of mine who's a whistleblower, and that client indicated that the Oireachtas that were about to introduce, in compliance with EU law, a newly amended Protected Disclosures Legislation 2020. There is an existing Protected Disclosures Legislation 2014, but certain deficiencies were pointed out to it. So I approached, on the instigation of my client, who thought I would be a useful person, my former client, to comment on this. I approached the Oireachtas Committee, and they didn't respond, save for the Sinn Féin party. And the Sinn Féin party, I had a meeting with them. Obviously, in this universe, that meeting is a remote meeting. And between one thing and another, they have asked me to draft a private member's bill that they propose to introduce by July 31st because of perceived and actual deficiencies in the existing whistleblowing bill. And I've got a team of people around me to assist me in that particular respect. But
how long have you been dealing with whistleblower in Ireland?
I've represented whistleblowers in the inquiry into our banking inquiry. I continue to represent and have represented Garda whistleblowers. I have represented corporate whistleblowers, and I have presently somebody who intimates that they are a commercial corporate whistleblower. So I've got extensive experience of it, coupled with the fact that I lectured for one semester whistleblowing and dismissal law, or whistleblowing law, in Middlesex University, and have extensive materials. And I've also written 2 articles, one in the Village magazine and one in Broadsheet, on the pitfalls and thing of whistleblowing. So it's certainly something that I know a considerable amount about, and have represented.
And tell me, what exactly is wrong with Ireland handling of whistleblowing as a practice?
Well, I think there are a number of things. I mean, the first thing is the Act is only seeking to introduce private whistleblowing regulation. The real problem in Ireland, given the nexus of corruption of the place, is state corruption. So you need regulation of whistleblowing and provisions that deal with whistleblowers in the police, whistleblowers in the departments of the civil service, whistleblowers within the structure of inquiries, whistleblowers within the structure of the public healthcare system, and indeed the prison service. And the present bill does not address that. And that was one of the major issues that the Sinn Féin party felt I should address with the team I've assembled. That is one deficiency, I suppose. But the other deficiencies are all the documented literature suggests that there is no point, really, and the EU eventually didn't put it in as a mandatory requirement. There is no point in having a structure where a whistleblower is subject of necessity to internal procedures before they go externally. The reason for this is internal procedures are usually invoked to bully, submit, demonize, ostracize the whistleblower. They're usually the very people who want to cover up the whistleblowing in the first place. And in a culture like Ireland, there are very few independent people who take this seriously. So a whistleblower has to do a jump skip and has to be able to circumvent the internal processes and procedures of the corporate or public organisation that they're in. And that means a whistleblower has to be allowed, I think, go outside that organisation to the press, for example. The difficulties we face in this context is Ireland doesn't, absent Cassandra Voices, maybe Broadsheet and Village Magazine, have a properly investigative press anymore, who are controlled by the established parties, who are the parties who are concealing all the levels of misconduct and wrongdoing. The protective disclosure legislation deals with wrongdoings, criminality, miscarriages of justice, layers of corruption, financial maladministration, malfeasance. These are the exact sort of things that exist within the public sector in financial, corporate, public issues, and the intersection between the state, the banking structures, the departments of finance, justice, and health, and so on. And also, Sinn Féin also wanted something I hadn't thought about, but they're very concerned about the control that the top civil servants have in Ireland, and to make not so much politicians accountable as to make the top civil servants in the various departments accountable. My very saying that, I think, will cause alarm bells to run through some of the civil service entities in Ireland, which are truly disgraceful. Then the other thing that is important is to examine and look at the question of an ombudsman. Now, that is contained in the government's proposal at the moment, but the difficulty is, having had experience of litigating ombudsman-related cases in Ireland, where the ombudsman is either a property ombudsman or an immigration ombudsman or someone of that nature, they're often governmental appointments, stooges of Stalin or stooges of Varanka, if you could put it in these terms. And such appointments are, in effect, appointments who are controlled in what they can do and what they do. And they're not necessarily independent. So the function of getting an ombudsman is to get someone who's an independent ombudsman, as opposed to somebody who's basically a governmental employee. It's the same problem in Ireland all of the time, given the agency capture of various entities.
So, can you tell me in a nutshell, in a few minutes exactly, what's the current legislation cover and if it tackles this culture of antagonism towards whistleblowing in these institutions?
The current legislation covers things like criminality, wrongdoing, corruption, financial maladministration, miscarriage of justice. It's extensive to that extent, but the problem is it doesn't matter how extensive the coverage is in terms of protection. Having listened to litigated whistleblower law, it doesn't matter if you're protected from prosecution and state breaches or confidentiality issues if the culture is not receptive to whistleblowing. So the the person I represented in the inquiry into the inquiry in whistleblowing in Ireland, the second day of the case, the first effective day of the case, the police got wind of this and they SWAT-spotted her and threatened her with breach of the Official Secrets Act. So to intimidate her not to go ahead. So if you've got a culture of bullying, harassment and intimidation, you could have, like the Soviets had a fabulous constitution that protected every right under the sun. It was utterly meaningless. You could have a whistleblowing statute that protects everything, but not if the Department of Justice and the police and corrupt politicians get involved and do a gangbang. And so I think what we need to do is create a culture which is more receptive to it. The Canadians, Norwegians, noticeably have a culture in that respect. And that, in Ireland, I think means forcing people to do certain things. It means creating an independent ombudsman, allowing for external reportage. It means possibly, I think, bringing someone in from completely outside the country at this stage. It means also the tightening of public whistleblowing. The difficulty with the way public whistleblowing is handled is that within the 2014 Act, it was delegated to a retired judge, or at least as far as state security, diplomatic issues, external issues are concerned. Well, that's the problem with Ireland, that this person is putatively independent, but not in reality independent. And we need to have a structure where public whistleblowing is also in reality independent. Other considerations are how to protect a whistleblower during the whistleblowing process, which can be extensive, given the reprisals, the demonisation, what Clara Kenny, an academic in Galway, called both the demonetisation of the whistleblower and the turning of the whistleblower into potty or mush, or the turning of the whistleblower into being engaged in what's termed quasi-psychotic speech, or what Kenny calls quasi-psychotic speech, which in that particular context means that the whistleblower is so bullied, ostracized, tortured, in effect, or hazed, that the commentary he's making, therefore, can therefore be regarded as not to be taken seriously. And there is no doubt within Ireland's professional bandit professional classes, and psychotic civil servants and political classes, it's very easy to target someone. I've certainly seen significant evidence of it. So you need care for whistleblower. In practical terms, in America, within the structure of what's called the Sarbanes-Oxley Act, they protect the whistleblower with making sure she is or he is paid. They provide them with a lawyer who is paid, and cash settlements can be quite substantial. And I think we shouldn't put a necessary cap on a cash settlement in this particular context, and we should try and fund through a legal aid structure, something that gives the whistleblower legal representation, legal entitlement through the process. That's certainly
and correct me if I'm wrong. All of that is not covered. Is not covered.
No. None of that is covered.
So there is no legal advice, free legal advice, or.
Well, yeah, I think we need actual paid legal advisors in a legal aid structure, and I think also it might be useful to incorporate some level of therapy. Aftercare. The Innocence Project, for example, has always provided for aftercare for those who are exonerated.
Yeah.
I think it's important to provide for aftercare for whistleblowers as well, or care through the process, so that they have a structure where they don't feel that they are being attacked. And they probably have to remove themselves from the workplace, because as the whistleblowing complaint goes through the channels and procedures, and those who have or are party of corruption will seek to persecute them. But equally, the flip side of the argument is this. There is whistleblowing, just as it is easy to make a criminal accusation against someone, it is also the case of false allegations, and false accusations are made. So one thing I've also suggested is that we need, I think, also to balance the argument out, and this is done in other statutes as well, to penalise those who engage in false whistleblowing allegations. The question becomes who determines what is true and what is false, and one has little confidence in the independent adjudicative and determinative methods of state-appointed officials in Ireland. They are more likely to conceal their own institutionalised corruption, to demonise the whistleblower. So it's a very tricky thing.
I wanted to ask you, can you give me an example, for example, of somebody who sees something that is wrong in his workplace? I don't know if it's private or public. What is the path that is to follow to effectively become a whistleblower? And
well, say for example, senior police officer sees that the police are actively framing people for child sex abuse, for example. The process of complaint in that particular context is that the police officer in question, or those in question, would have to make an internal complaint within the police. But that's a bit like, saying, I don't agree with Hitler's policies when you're in the German army. Those at the top of the police force who are part of corruption, the pattern is to frame you. So this is the problem with the internal procedurals.
Okay. So basically, before someone can go to an external institution,
yes, there can be no barrier statutorily to someone going to an external body or agency or the press.
Okay.
Having had to have exhausted internal procedures. Because if they have to go through the hoops of internal procedures, those procedures will try and demonize them, exclude them, diminish them, and have a vested interest in not.
At the moment, you can only reach an external institution, right?
Well, it might be the press. I mean,
it might be the press, or it might be
whatever happens in the outcome of the bill. You cannot say you've got to go first internally, appeal it, and then go to an ombudsman before you go to the press or an external body. Because at that stage, the system has wrapped you up and destroyed you.
So what you're suggesting then, that has to be some provision of protection for people who literally go straight away to an external...
Exactly.
And at the moment, there is none of that. So basically...
Well, it depends how the actual language pans out in the actual final analysis of the bill. Certainly, I would put trenchant clauses in relation to existing bill.
Can I ask you, and does the nature of the misconduct of crime or whatever it is that the whistleblowing is trying to denounce play a role into listening to the whistleblower and protecting the whistleblower? How?
Well, I think in conjunction with the allegation, the whistleblowing allegation, we need to build in a procedure where the whistleblower is like plucked almost and immediately protected. And that means that there must be a body the whistleblower can go to that can give them a income structure if they were suspended from the workplace or something like that.
If they can,
that can assess, that can protect them through the whistleblowing process. So that their livelihood is not affected, and so that they don't have to interact with people who they're blowing the whistle on in the workplace. I mean, this is the imperative in our culture of compliance.
So basically, let's say that somebody in the police force sees something that he believes goes against the public interest, and he feels compelled to denounce it. Now, as things stand now, they first technically have to go to the chain of command of their police force. So they have to complain their behavior to the superior,
exactly.
the immediate superior, and the immediate superior and stuff like that.
Yes, exactly.
And that also work for
the civil service.
Now, the problem is that, as we spoke yesterday, that normally this kind of culture of behavior reaches most of the time the real top of the organization. So
Yes.
there is no internal process that can help the whistle.
No, that is the catch-22. That is the problem. And
Exactly.
the problem in Ireland is that the multi-hydrid nature of corruption of the state is most invested in the top civil servants, top bankers, top lawyers.
And you're saying that, so basically what happened is that the whistleblower has to be able to blow the whistle outside, so for example, to the media or on internet or like this. So the moment he does that directly without passing through the internal process, can be considered outlaw, basically, can be considered in breach of any law, for example, the Confidentiality Act.
The process, if you look at the process is to demonize and criminalize whistleblowing. If you look at one of the classic films about whistleblowing, which is Serpico, Al Serpico blew the whistle on the New York Police Department. They had him shot. He nearly died. He had a bullet to his head. He left America. He's never gone back, and he's lived a peripatetic existence around all of the world. So I think you've got to realize that whistleblowing has become a way where a very dangerous exercise, particularly in an overly compliant world where corporate and state structures are ever the more corrupt. And therefore, if you are to take it seriously, then you have to invest in whistleblower with appropriate levels of protections.